Okay,
Got it.
sounds good.
Okay. As many of you may have heard or known, Catherine Fry's under the weather, so I am batting cleanup or coming in for relief pitching, whatever the baseball analogy you want to use. Let's start with the ethics statements. The duty of the subcommittee members to avoid conflicts of interest in performing the duties as a member of the subcommittee studying unbundled legal services of the North Carolina State Bar. Any member of the subcommittee who is aware of any conflicts with respect to the matters before the subcommittee should disclose those at the meeting. I doubt we're going to have any, but welcome everybody. We do have quorum. I think in the email we had the minutes from the August 22 meeting. Are there any changes, corrections, or additions to those? Seeing none, the chair would entertain a motion.
I'll move approval.
Second.
Motion and second. All in favor? Aye. All right. Opinion of the chair, ayes have it. Mary or Brian's about 10 minutes out or 5 minutes out. Mary, do you want to start with the revised one, and then when Brian gets hooked up, he can jump in?
Yep, I can certainly do that.
Okay.
So you all have the revised draft starting on page 4. I'll just walk through and kind of go section by section. There's a number of the sections at this point that there were not any changes made based on our last conversation, or if there were changes, they were more tweaking kind of how language is ordered and not necessarily substance. So I think there's really only 2 sections that are a more substantial change than what you last saw. So limited appearance, first provision, I believe there were no changes at all to this provision. It's the same and really just sort of setting the stage to define limited appearance, referencing back to 1.2 in the rules of professional conduct, which, kind of, I guess, helps to set some guardrails for what that limited appearance is supposed to look like based on the ethics rules. And that's kind of it. So no changes to A. Section B of the draft previously was notice and service, so we've just limited it to the notice piece only. The first piece about the filing that's supposed to be made, that's unchanged in terms of all of those different 1, 2, and 3 that are laid out. That is exactly the same as what it was. And I believe the tweak here is that there was just a little tweak in the sentence order to make it read a little bit more nicely. But it otherwise is the same. And then, of course, you'll note the placeholder at the bottom, which I think was a reflection of our conversation about e-courts and some potential reference that may need to be made there, especially for those counties that are now on to that system. I should have stopped and asked for questions on either of those provisions, although I think this isn't the really the part of the discussion where there's more meat. So
I don't believe this is the contentious part of it, unless I need to be corrected. Any questions? Any questions? Okay. Go ahead, Mary.
So then scope, this paragraph is the same as prior versions. It just has moved up from a later section in the document. So it's the same in terms of requiring the attorney to restrict their activities to that which was described in the notice, and requiring that if you make a motion, you enter a motion or pleading that is outside that scope, you will be deemed to have made a general appearance. If you want to amend the scope, you have to do that. And if the scope is disputed, then the judge can hear that issue. But otherwise, really, that's the same as prior versions. Oh, I see Brian is back. I'm going to let him enter back in. Okay. And then D for the
Hey, let me ask a question. I just thought about this. I'm going back to C here, going back to B, go back to B. The last sentence talks about it until the conclusion. Should that be until the conclusion or until the withdrawal? Which
actually, I'll look.
Are they one and the same or not?
Well, I actually feel like our prior version may have been using that word withdrawal, which then was causing confusion. Let me just look back. Let's see. Hold on.
Yeah, Mary, you're right. That was, I think the prior version talked about withdrawal, but there was this question about when does withdrawal officially occur, and does that lead to confusion over, when is the person no longer responsible? And so we went and just said the conclusion of the matter. That was the discussion last time.
Okay, I don't want to prolong this. Let's just put a pin in that spot, right, that sentence right there, because it may need to be reconciled with section E in terms of the withdrawal. Whether we use conclusion of the representation or withdrawal.
Okay.
You see what I'm saying, Brian?
Yeah, I'm pulling up the text right now. Yeah, I think that was this is kind of like where we're getting into the details, the nitty-gritty, because
That's right.
It's this question of, you may conclude the representation, but then withdrawal isn't effective until you file that notice. And I guess that's the thing. You're right. There's a reconciliation because there's a new method of, I guess maybe I should say subsection E is kind of redrafted to make it a more clean exit. Correct. As we were discussing last time. So maybe we can go back to using the term withdrawal.
Well, just put a pin in it and we can come
Right.
back to it and make sure we reconcile the two if needed.
Right.
Okay.
Any other comments? Welcome, Alice. Yeah, I see what Todd's saying there. Okay. Mary, Brian, welcome from the traffic jam. Mary or Brian, you may proceed.
Well, we were on D, service, which is now its own paragraph, used to be kind of together with the notice. The substance is largely the same in requiring both service of all pleadings and communication regarding the case go to both the limited representation attorney and to the party or parties. The change here is that it adds the ability for the parties to agree otherwise, essentially. So I think it's maybe a balancing of, requiring no matter what that service and communication to go to everyone versus not, which I think has been something that we've gone back and forth on during our previous subcommittee discussions. The other change I just wanted to note based on the last call's conversation was to change the endpoint of the requirement. Let's see, I think this language was updated, Brian, wasn't it? To reference, sorry, I'm just trying to find it here.
It's a withdrawal, probably.
Yeah, it does reference withdrawal. So,
and I guess I just want to kind of make the point that those conclusion of the representation and withdrawal might be within the same act or moment, but then we also wanted to recognize that somebody could withdraw from the representation in the middle of a limited appearance, and you have not concluded your limited representation, for whatever reason. And so that's why it feels like you're talking about the same event, but they could be different. And so why it's kind of choosing which one is appropriate. Should you say withdrawal, or is it conclusion of the representation and all that kind of stuff? I do think that withdrawal probably is the better term. But that was, again, that was a product of the conversation last time to not focus as much on withdrawal. But yeah, the other thing that I wanted to point out with service, like Mary said, this is, I think the one of the big points of contention last time was this question of should the limited scope representation attorney get everything that is sent from the opposing counsel. It's that question of who bears the burden of determining what is and is not appropriate for, or what is and is not relevant to the limited scope representation. And really, you have one of two options. You can either say it's on the opposing party to just send everything, and therefore not run into that issue, and then it's kind of on the receiving attorney to say this is or is not relevant to what my limited scope, or you ask the opposing party to make that decision, which could potentially bring about some difficulties and some issues if somebody says, well, they didn't send me that letter, they didn't send me that filing that clearly implicates my limited scope, even though it's more of kind of a like an indirect relationship. It's that question of, I think where we landed when we were drafting this is it should probably just all go to the limited scope attorney, and he or she can then make the determination of what is or is not relevant. So that's the way that was drafted. And of course, it's also, you have this this language in there, unless otherwise agreed upon by the parties. And that was very intentional to offer the parties the opportunity to say, hey, we can work this out ourselves. The default is send everything to the limited scope representation attorney. But if the parties otherwise agree that, hey, we can modify this, you don't have to send me everything. My limited scope is such that it's very clear what is and is not relevant to what I'm doing in this case. The language is supposed to offer that flexibility for the parties to essentially figure it out for themselves if needed.
And maybe this is not quite the time for it, but now that we are like the newest kid on the block with Odyssey,
right,
let's throw in that little piece. I know we talked about e-filing. Two pieces is for the attorney to see everything on a case. They would have to be the attorney of record. So when they do that notice of appearance, the clerk's office, who has the rights and roles to do that, will add them as the attorney of record for that time frame. That way they can see all the documents, they can see everything that's going on with that case. Also, given to me by one of the AOC folks, they made some minor adjustments to talk about electronic, Rule 5 electronic service. And this is what the part that is added to it under Rule 5B1. Which is with respect to persons served through the court's electronic filing system, an automated certificate of service generated by the system satisfies the requirements of this rule. So that's where the language is going for Rule 5B1 for rules of service. So just wanted to add that in there. When they do that notice of appearance, they will be added to the case. So it will have to be something that clearly tells them they're out of the case, so they can give that to the clerk's office so they can be removed from it. And then that part in 5B1. So I just wanted to add that to the conversation.
So, Dr. Rice, can I ask you, from your perspective, kind of now you're seeing how the system operates and kind of on the, like, I guess just the other side that, or one of the other sides that you can see how this thing is functioning internally. Does this provision almost like outside of the communications, just as far as service of documents, once everyone is on e-filing, does that provision become moot?
I think so, because, there's also a change in the rule about attorneys having to use that system as service. So they have to provide their email address and they have to accept service through that way. So then if a notice of appearance is done, I can do a file and serve. So I do my limited notice of appearance. And then if I do file and serve, once the clerk's office has accepted that notice of appearance, then the party that I click, the other attorney, knows, because they're going to get a notification that says, hey, they have this document that's on the case. And so he can see that here's my limited notice of appearance. And then when they sending something, one, that almost gets rid of it, because once you're named as a party, you can see everything on there. So right. sending something to somebody or notifying them of what's on the file shouldn't be necessary at that point in time. Discovery still will be, but not necessarily the complaint, civil summons, any amended complaints, answers and counterclaims. Those documents will all be on the case. And when they become a named party to the case, they'll be able to see all that.
Right.
So I think
still needed for discovery. That's right. That's and just all those things that don't actually get filed. Okay. Right.
Brian, this is Marcy. I think in domestic cases, some stuff is relevant for different issues. So I do think I like the idea that that the opposing party has to send everything and let the attorney the limited scope decide if I don't want somebody deciding for me, what's relevant in discovery and what's not.
Yeah, I hear what you're saying. I think Gina's concern last time was if you get everything, then and you receive something that you almost like that this is not in the client's best interest. Does the limited scope attorney have some sort of duty, even whether it's necessarily imposed under the rules or just kind of almost as just a professionalism duty, to then not like expand your scope officially, but to tell your client, hey, this is going to be really bad. I feel like I see this. I see what somebody's, filing here. They're requesting, they're petitioning, whatever it is. You need to pay attention to this, or maybe you need to take this approach because otherwise this is going to turn out really bad for you. And I think Gina was afraid of the kind of the ripple effect of receiving everything, even though you say, I'm only going to be talking to you about, the mediation coming up. I'm only representing you on this deposition, what have you. But, does it kind of implicate this, I guess, just this notion that you, as the attorney, if you see something, you need to say something. I get what she's saying, but I don't know if there's a workaround that.
I still wouldn't change it. I mean, I would hope a lawyer, if they saw something, they would warn their client, even if they weren't representing them on that issue. But I still don't like the idea of opposing counsel deciding what I need to see.
Yeah. Is there any other feedback on that?
Now I've got a question to Dr. Rice. Dr. Rice, you said with the Odyssey, if a lawyer enters a notice of appearance and the clerk puts his or her firm information in the system, I assume. If a defendant is sued and does not have a lawyer, does that party gets access to the Odyssey system?
Yes. So what they
how do they get it?
So there's 3 systems in total. So it's called the integrated case management system. The first system, which attorneys and stakeholders operate in, is called File and Serve.
Yep.
That is not part of the main system that the judicial folks operate in. So clerks, judicial support staff, all of them operate in Odyssey, separate system. The third system is called Portal. That's where you can see cases. You can see documents that have been attached to cases. You can see everything related to the case, other parties. You can see the judge assignment. There's a lot you can see on the case. So it kind of replicates the file itself, along with what has been filed. So if there's a counterclaim file, you can see that counterclaim on there. You'll know because it says counterclaim, and then you'll see the case. So we operate as court staff, we operate solely in Odyssey. The public operates in File and Serve, and that's attorneys and pro se.
Yeah.
And then the public operates in Portal, which is attorneys and pro se. And so that when you're added to a case, then that gives you what they call elevated access in that case that you're a party to, that you're an attorney on. And so that means you can see all the documents in that case. If you're not able to see basic information about it, you won't be able to see that. You'll see that there's a complaint file, there's some motions, you'll be able to see that, but you won't be able to see the documents on the case. And so that's kind of how that works. So in a limited appearance such as this, the clerk's office will have to add you to it so you can see. Let's say it's a custody matter and they contact you after mediation. You want to see the complaint, see what was being said, see what the counterclaim was, what they're asking for there, so you can get prepared. I do agree that you probably still want all the discovery. I will agree with that. You wouldn't need the basic items, basic documents on the case, you can see it in Portal. But I do believe you want any discovery that you feel is going to best help you represent your client. So hope did that answer your question? Or did I kind of think around a little bit?
Yeah, that's adequate. I mean, you say that typically discovery is not filed in the system anyway, so that there's no change there. I mean, there's nothing that's changed.
No change in that. And
so
that's
the
why
discovery is not going to be in the system anyway.
That's why I agree that the attorney should decide
Yeah.
what level of
Okay.
discovery they should get, but they can see the basic complaint, summons, counterclaim. They can see those documents.
got it.
And this-
Thanks.
You're welcome.
Any other questions? Just my opinion, I think we still have to write it this way, and because I mean I think the anticipation is 2024. Everybody's going to be on Odyssey, but we can't bet the farm on that. So I think we have to write it both ways, and maybe the day will come that we go back to the Supremes and say, hey, we need to fix this and delete paper references, so to speak.
Right.
Okay.
Yes.
Well, then you want to go to sub E? I guess, Barry,
Yeah.
I could take this one. I know this was probably one of the larger discussions last time. Last time, you remember we were talking about the prior proposal was kind of a more complicated way for an attorney to withdraw from the limited scope representation. There was a filing of a notice of conclusion of the representation and an opportunity for someone to object, and the court has to basically, if the court doesn't act, then the withdrawal becomes effective 10 days later. And I believe Gina felt like that was potentially just too complex of a scenario and process that would serve as a deterrent for folks to get out. And it was just kind of this big question of, how do we make this clean? Do we rely upon folks to do the representation, they conclude the representation, and then they're done? They just file the notice and they're done. And that's what the draft before you now reflects. Did go look at some of the other states that have this, and as you all may remember from the very first meeting, Mary collected a lot of different rules on unbundled services, and there were some that were very basic, almost to the point of being vague. And then there were some that were very detailed. And we tried to land kind of in the middle. And this is one of those points that I think maybe in getting more specific than we were kind of creating a situation that might actually serve as a deterrent for folks to actually get into these limited scope representations. So the provision now reads that basically an attorney who's doing this limited purpose shall be deemed to have withdrawn from the proceedings without the need for permission from the court when the purpose is fulfilled and upon filing a notice of conclusion of limited appearance. That when the purpose is fulfilled is some language I've seen in other states when they're talking about, and actually I believe that when the purpose is fulfilled, I'm going to take that back. I think that is the language from our statute that permits limited scope representation in criminal matters. That it's just a straight, when you're done, when the purpose of your limited scope is fulfilled, then you're deemed to have withdrawn without need of leave of the court. So I kind of took from that this existing language because I think it does actually communicate what we're talking about. When you're done, then you file this notice of conclusion of limited appearance and you are deemed to have withdrawn, and that's it. Of course, that notice of conclusion needs to say that everything is done. It needs to include the most recent contact information of the party that is now unrepresented, and that all future filings and communications and so forth need to go exclusively to that person unless another attorney makes this either limited or general appearance. The thing that we've deleted is the whole process by which someone might have an opportunity to object. Does the client have consent? Does the client not have consent? All that kind of stuff. And I guess one of the reasonings there is that, again, we're trying to make this clean. We're trying to make this an attractive process. But I guess I kind of reason that realistically, if somebody objects, they're going to object. They're going to let the court know. If the court has a problem with it, the court is going to make some sort of point there. They'll call somebody back into court to talk about it. If the client just refuses to, we don't want to create a situation where the client can effectively hold the attorney hostage because they think that the limited scope has not been achieved, even though it very much has. And so I drafted this, I guess, in a way that would be very clean to just say you file your notice and you're done. and kind of relying upon what I think is the reality that if there's a problem, people will bring that to the court's attention, whether it's the court or whether it's opposing party or the client, and the court has processes to deal with those sorts of things. It becomes just another civil motion or whatever it might be. So that's and then of course the last sentence there is just kind of recognize that at any point during the representation, a lawyer may need to withdraw and may file a motion to withdraw, even if the limited scope has not yet finished. We can all understand that there may be a point where the attorney-client relationship just breaks down, whatever the case may be, and that the ability to withdraw still is generally available under Rule 116 of the Rules of Professional Conduct. So that's subsection E. Would love to get some feedback.
Brian, I agree with Gina. This is Marcy. I as a family lawyer, we don't always have reasonable clients, very emotional. And in their eyes, their case is never going to be over. So I like the way it's written. I mean, if you want to try to get family lawyers, which I understand is one of the big areas we're trying to attract, if you want to do that, you definitely need to keep it this way, in my opinion. I agree with Gina.
Great.
Brian, do you think the court on its own motion can bring something? We talk about the client holding hostage. Is it the filing in the court? Like you said, the court just, come on back in. We need to talk about this.
Yeah, I mean, I guess that's one of those things that I feel like, can a court issue some sort of order to appear, almost a show cause-esque type of thing, just to say, hey, wait a second, I need you back in here. And I guess maybe that's the question. We have this, a motion to withdraw. The current process would be that a lawyer files a motion to withdraw and it has to be granted by the attorney or by the court. I guess maybe I don't know if there's any sort of procedure. I feel like a judge could do this, but if the motion to withdraw is granted and there's something that comes up later on, and maybe it's information that the court would have wanted to consider in resolving that motion, could the judge issue some sort of order for that attorney to appear and answer questions that the court may have? I mean, I would think that the court can, but I don't know, Marcy. Yeah, what do you think, Marcy?
Well, I mean, I know what would happen. I mean, you have somebody shows up in a domestic courtroom and says, well, so-and-so represents me. The judge checks the file, the portal, whatever, and sees, well, there's withdrawal. And that person says, well, wait a minute, I didn't know that, whatever. Then she'll get the clerk to pick up the phone and call the lawyer and get them to come over and talk about it. I mean, if the court thinks it's worth doing that, the judge may just explain to the person, what's going on, and that may resolve it. And then I guess there's always something similar to a Rule 60. I guess if the judge finds that the lawyer has done something wrong and getting out too soon, I think the inherent powers of the court can take care of it. So I think it can be taken care of by the judge.
I've got a different view on it, as I've said before. There's nothing in this rule, in my view, that protects the public. It allows the lawyer to decide when he or she has concluded the work. And therefore, this rule as written would allow that lawyer to simply file a notice of conclusion and he or she is out. If the client, the member of the public, wants to have a hearing to contest that, in some of the larger counties like Mecklenburg, it could take that person 2 or 3 months to get on a calendar to be heard in the normal course of things. And in that 2 or 3 month period, that party who was represented by the lawyer who's withdrawn could be harmed because he or she has no representation at all, but he or she is still in that lawsuit. And so, to me, I understand everything about, and this is what we talked about before. If we want to get into the notion of having a separate, discrete practice area, like family lawyers have a different set of rules than everybody else, we can talk about that. But right now, as I see it, the way this rule is written, and tell me if I'm wrong, Brian, and everybody else, the lawyer gets sole discretion to say, when I have fulfilled my purpose. If the client disagrees, so be it. If that lawyer files his notice of conclusion or her notice of conclusion, by this rule, upon the filing of that notice, he or she is out of the case at that very moment. And somebody could file a Rule 60 motion, which is probably about the only recourse, I think, is to file a Rule 60 motion on, some mistake or some problem or some fraud or whatever. But to me, there's nothing here that gives the vulnerable party who's now going to be without a lawyer any recourse to object to what the lawyer might do as this is written. Now, if I'm wrong, just tell me I'm wrong, but is that not the practical effect of how this rule is written?
I think you're absolutely right, Todd. That is the practical effect. And I think that was kind of the balance that we're trying to figure out, because the prior version basically afforded a lot of that protection and opportunity to object and things of that nature. And that's what caused a lot of discussion last time, saying, well, if this is how it's going to be, then you basically have a client that can hold a lawyer hostage and hold them to the case. And you're basically back in the same spot that we are in currently, where you need to file a motion to withdraw to actually get the court to get you out of here.
Well, the problem I disagree with that is that the lawyer can't be held hostage. The lawyer can file a motion to withdraw as provided by this rule and as provided by the applicable rules of civil procedure. So there's no way a client can hold a lawyer in. The lawyer simply files a motion to withdraw, tees it up for a hearing. The judge agrees or not. But there's no way for the client to hold the lawyer in. The lawyer just files a motion. The flip side of it is not true. The lawyer gets to jettison the client when he or she deems his or her limited scope representation is over. Who gives a damn whether or not the client agrees that it's over, or if another party in the lawsuit has some problem with the withdrawal? This rule says nobody has any say in whether I get out of the case or not.
Yeah, no,
I mean I was looking. I've gone through this down here in Mecklenburg. I think the rule is the same in Charlotte. In Mecklenburg, if you file a motion, the clerks require you to send over some sort of written notice that the client has been advised of this and agrees to it. And in Mecklenburg, in Wake County, I think the rules require that the lawyers notify the client, and also that the client be added to the certificate of service. So there's some steps in there that ensures that the client has notice of what's going on. So that was one of my concerns. There's no protection built into this rule, which is currently built into some of the practices in at least some of the largest jurisdictions like Mecklenburg and Wake, where the local rules exist. And you can't get out without the judge saying so. And that is some protection for the public. The way we're drafting this, we're giving the lawyers sole discretion as to how we do it. And if that's where we end up, that's where we end up. But it seems to me that, what I consistently hear is that the family lawyers need this in order to be able to get in and do the work. And I don't disagree with that. But then maybe we carve out, some sort of rule that, takes care of the family lawyers and their concerns. But for this rule to be a blanket rule that can apply to anybody, it seems to be, it seems to me contrary to our notion of we're the last line of defense for the public. And we're protecting the lawyers because we're giving the lawyers the right to say, I'm done and I'm out, and I don't give a shit whether excuse my French. I don't care whether the client.
Live stream, Todd.
I don't care whether the client. I don't care whether the client disagrees. That's my hang up at this point, is that the client has no say as this rule is written. And I'll go ahead and mention this too. As I see this rule, there's nothing in this rule that even requires that the client get notice that this is happening. Unlike the other rules, like in Mecklenburg, you've got to provide the clerk some notice, something in writing saying that the client is informed and agrees or not. I just went through it, and the clerk said you got to send an email over from your client saying, I agree with you withdrawing your other lawyer withdrawing from this case. That's some protection for the at least some notice to the client. But as this is written, correct me if I'm wrong, I know it says we put the party's address and all that stuff in there, but there's nothing saying we send this to the client. And quite frankly, the way it's written, it doesn't matter if we send it to them, because if I put it in the mail the same day that I file my notice of conclusion, I'm out before the client even gets notice of what I'm doing, because this, as written, once I file that notice of conclusion, I'm out of this case.
Well,
So
it's not a local rule. Current rule 16 says it's got to be reasonable notice to the client.
No, they're all local. No.
There's local rules too, but
Yeah, and
current
they
rule
do,
16.
no, local rules address this specifically down in Mecklenburg and Wake, and Rule 16 doesn't really address whether you got to give notice to the client and all that stuff.
Yeah, it does. It says reasonable notice to the client.
Well, but there are other, but that it doesn't say in writing. I mean, so and
All right,
there's nothing in here. What's reasonable notice? I mean, is it putting it in the mail?
Here's a possible solution. What if you file it and it says it's not effective until 10 days, at which such time party can object?
We talked about that last time, we talked about that, and it's not in there anymore. So I don't know. I'm just saying that it seems to me there ought to be some consideration for how we protect the public by not having the lawyer simply say, I'm done with you. Even if you disagree, I'm filing this notice of conclusion, and by rule of civil procedure, whatever the number is, I am out of the case at the moment I file it. You can go file a Rule 60 motion if you want to and get it heard, but you could be harmed in between the time that lawyer disappears from the case as your lawyer and you get a hearing on that.
Right. So I think one solution we had before, the notion that the client had to sign that notice of conclusion, and perhaps that is something that would provide that reasonable notice, and we can include some language about reasonable notice in there. But but even just having the client's signature, I think goes to your point that the client at least agrees to it. The concern raised last time where we took that out was because if the client refuses to sign, then you have to go through the whole process of moving to withdraw, and nobody's going to want to do that if the client is being unreasonable and they're refusing to sign, and you have to file this motion to withdraw, at which point you're now trying to, like to your point with Mecklenburg, you put a motion to withdraw on and you're waiting a couple weeks, but while that's going on, the representation is going on, and you're not sure if you should continue to represent this person because you still have a general obligation to represent that client. I think this is where I don't know if maybe this is pointing to where this limited scope thing becomes untenable, because you have to choose one way or the other. And seeing how these other states have done this, it seems like they make a choice at some point with generally supposed to be, providing that notice, but like offering a quick and yes, in some ways, kind of unilateral out for the attorneys to facilitate these limited scope representations. But I don't disagree that I would like to see the client's signature on there. I think that's a very reasonable thing to request. But yeah, Marcy.
Yeah, I'm sorry. I hear everything that Todd is saying, and this is different though, because when you get involved in the case, the client knows from the very start that you are in for a limited time. So this is not the same situation where a client retains you for their whole case. So they know at the beginning of the representation that it is limited. So I don't think it's comparing apples to apples. Now I do, having said that, if you make it to Commerce, then we just might as well just disband this subcommittee, because it's just a waste of time. Because that's the whole point, is trying, and these people that are getting limited representation, they would have none. So the idea is some representation is better than none, because they're at least getting some help, and they know going into it, it's limited. And so I don't think it's the same thing as somebody hiring somebody for their whole case and then somebody trying to get out without giving them notice. I do think they need notice. I don't know I'm sorry, I'm in my car and I can't remember what it says about, the lawyer getting out and the notice and all of that. I mean, I don't want a client having to sign it. I don't.
Yeah, it does not say that the notice needs to be served on the client or anything like that. And I think that's a very reasonable thing. That's an oversight. It should at least say that the notice needs to be served on the client.
You could say it needs to be served, on the client, but within 15 days before you file it. Or something.
Yeah.
I can see.
Well, that's what I'm suggesting, Marcia. There be some sort of process or procedure whereby the client knows what's going on. For example, in Wake, it says moving counsel is responsible for providing the client with appropriate notice of the hearing to
Yeah.
withdraw. So
Oh, you have to do that. We all do that. I mean, when you file
our
a
rule does, this rule as written does not say that. Is what
well, I
I'm
don't think we
saying.
should have to have a hearing. I don't think there should be a motion. I don't think we should have a hearing. I don't think that the client should have to sign anything. I think that you got to make it simple, or you're not going to get anybody to do it. So, I mean, but I do agree that you could maybe put in the rule that the notice, whatever, the notice has to be sent to the client X number of days before it is filed.
Before the notice of conclusion is filed.
Right. So you
Yeah.
you do a short number of days.
That's all I'm suggesting.
And you can attach to that notice that you serve the client like we do anything else, any other certificate of service.
Well, we're saying the same thing. That's exactly all I'm suggesting, that the rule needs to be.
I thought you were saying that we have to file a motion and the judge has to hear it. I mean, I don't want to do all that.
No, well, I said as written, that's what there's no chance to do any of that. If there's some disagreement over whether or not, if there's some disagreement between you and your client as to whether or not you have performed the limited scope representation, you say yes, they say no. As this rule is drafted, you trump the client every day of the week, and the client has no say in it.
Yeah. Well, I mean,
is
I
that
think
right or is it not right? I'm just saying, let's talk about, is
It
that
sounds
right
like,
or is that right?
we're on the same page. And for those of you who are not an officer, this is a glimpse of what an officer's meeting looks like. Todd and Marcy arguing and then realizing they agree on the same damn thing.
And
that's after a couple of splashes, and we get into the weeds after a couple of splashes.
Anyway, does anybody else have anything to say?
I mean, Brian, Brian and Mary, I mean, is there, I mean, is it?
No, you're right.
I haven't looked at what the other jurisdictions have done, and if I'm way off base, as I tell Matt all the time, I'm happy to be wrong, except if he tells me I'm wrong. But if I'm off base, guys, I mean, just let's move on. I think
you're right. I think we do need to include language that I think the language about, that basically prior to filing the notice of the conclusion of representation, the attorney shall inform the client of the intent to file, no later than what do you want to say, 10 days, 15 days, something like that, but providing some sort of direction that the attorney lets the client know, hey, I'm filing this. We're all done here.
Let me suggest this, and then we can move on. Maybe looking at the rules might help. In Wake County, it's local rule 3.5, and in Mecklenburg, it's local rule 12.8. Those deal with withdrawals through a motion, and it sort of might provide the language that we can include in this rule for not having to file that formal motion to withdraw. So just look at what that language said. And it talked about how clients shall get notice of what's about to happen.
I mean, are we going to get I think that we agree on the concept, and I think that's a good compromise. The service, though, how? I mean, we typically email with our clients. I mean, so think about that. I mean, or can you make it general, just notice, so you don't make us have to go serve it with a sheriff, or, I mean, again, trying to make it.
5 is fine.
Yeah, I think 5 is fine. Yeah.
Okay.
Rule 5.
All right. Just want to make sure everybody's. Make it as easy. I agree. They need to have advance notice, but I also want to make it as easy to get in and get out, or we're just defeating the purpose.
I agree, Marcy, 100%. I disagree with the notion that the client can hold the lawyer hostage, because the lawyer can always file a motion to withdraw and get out if the judge allows it.
Well, that's a big if. I'm gonna tell you something. I don't know what happens in Mecklenburg or Wake, but there are not that many good family lawyers in some of these smaller communities. And, sometimes it's a little hard to get out.
I got it. I believe you. I'm with you 100%. I get it.
Okay.
But I think we're potentially striking a good balance here if we put some notice in there.
Okay.
That allows the lawyers to get out much easier than having to be stuck in there forever. And I'm all for that. I just want to just give a little bit of notice to the client.
I'm good with that.
All right, I'm going to come up with some additional language for notice to the client to put there in sub E. And I think that concludes what we did to this draft.
Okay. Procedural question, and I really don't know the answer to this. the officers are going to meet with the Chief Justice on that Tuesday before the meeting.
Mhm.
I don't want to necessarily give him a draft, but I would like the committee's permission for Marcy or Todd or myself to kind of say, hey, this is what we're working on, and get a sense of where he is on things like we're talking about now. I mean, we can do all this and they say, no, we want it to be 30 days
That's
now,
right.
or something like
Right.
that.
Right.
Because I mean, without a shadow of a doubt, they're the ones that write the rules. We're just trying to
That's right.
draft it for them.
That's right.
Right.
So is it kind of the consensus of the group that I'm not seeking to send a draft over per se, maybe at a later time when we have a cleaner one, but I would like permission from the group to kind of mention this to him and say, this is something we're working on. Do you have any hard and fast thoughts? And he may not have any, but I think we need to report to him.
Matt, he knows we're working on this. I don't know how I don't know if he's ever actually told me, how he feels. And I think he's just kind of waiting to see the specifics,
See
but
the rules, yeah.
clearly knows. I've told him, I've talked to him about it. So, and it's been in my president's message, which he told me recently he had read. So I'm just saying he's not going to be surprised that we're working on it. But I mean, we can maybe give him some more of the details.
Yeah, that's what I'm thinking. Some more. I'm not saying a final draft, but maybe something of, this is where we're headed. I don't do all this work and then get it to him and say, hey, and get rid of the notice provisions or whatever.
Right.
Okay.
Right.
Yep. Works for me.
I'll let you all know. I also have reached out. I haven't had a chance to really speak at length with this person, but the person that kind of staffs the rules committee through the Supreme Court that looks at the Superior Court rules or District and Superior Court rules. We've kind of been playing some phone tag lately, but trying to just talk about this. I know I've kind of previewed the issue, but just trying to understand their process by which they take something under advisement. They have a group of folks, number of familiar faces, like Judge Mike Robinson is on there.
Good.
And so forth. So we've got there's going to have to be some review by that group, at which point, I'm not sure what their responses are going to be, but clearly there's a process that we'll go through. I'm taking steps to navigate us through all that.
Well, what I'm hearing is clearly we won't have a final version of this by the October meeting. So we're kicking this down the road to at least January, and maybe we can meet between October and January to come up with. I mean, we're real close, in my opinion.
Right.
Correct me if I'm wrong, but a period here, a few words there, and I think we have a final draft.
I agree with that, Matt.
Sounds good.
Anything else? So that's what I think the next steps are, is that Brian and Mary kind of come up and add those little tweaks that we've talked about. And then we'll let them get back to, there's no way I don't think we can get back together prior to the October meeting. So we'll shoot for something after the October meeting.
That sounds good.
Thanks everybody for all your work on this.
And thank you, Dr. Rice, for the very quick Odyssey update briefing. That was unexpected. We didn't have that on the agenda, but I certainly enjoyed it.
Wait a minute. I don't think it's fair that Todd's not going to have to get, mean emails. Yeah,
What are you talking about? I was reading something else. What are y'all talking about? What?
I had to deal with all the angry people, and it looks like you're going to get off easy.
For Odyssey, you mean, or for this rule?
Yeah, Odyssey. Looks like you're going to get off.
This is the typical.
I've already told you, Marcy. I'm going to just refer to your wonderful article that you wrote on Odyssey, and refer to AOC, the expert. So that's my line.
As usual, I'm just paving an easy path for you.
Absolutely, and thank you very much for doing that.
And as usual, I'm ending the conversation.
Bye, everybody.